Today, we were getting all ready to hear the continuation of Adam Lally's testimony in the Miles King case. Now, what happened in the Miles King case is that the defense filed a motion to dismiss based on Brady violations and Rule 14 violations, which would also include prosecutorial misconduct. So we have to have an evidentiary hearing. Some judges actually do hold evidentiary hearings. So the evidentiary hearing started a couple weeks ago. We had Adam Lally on the stand for a couple hours. And then today was supposed to be the continuation of Adam Lally's testimony, and then also move on to former Trooper Michael Proctor, and then perhaps even to Lieutenant Tully. Well, that was all canceled today. And why is that? Well, the judge said that he wanted the parties, meaning both the prosecutor and the defense, to meet and confer, to get together and create a chart showing exactly which discovery was turned over when, what's late discovery, and then also so that the defense can make an argument about which pieces of discovery, because they got the late disclosure, prejudices their client, and therefore it's going to be an unfair trial, which would then be a reason why to dismiss the case. So this is what he wanted, and to be fair, he didn't ask for this at the last hearing, but I want to show for you and play for you the difference in his tone, the difference in what he did about this specific issue that he wanted and how he conducted the hearing. So let's just see the difference, and then we're going to show you what happened, I think, what created that change, and we're going to see whether this evidentiary hearing should have happened anyway. So let's start with last hearing when they discussed this specific issue. Okay, so they discussed this exact issue about which discovery is when. And again, there's voluminous discovery. There's like 300 documents of discovery that was not turned over. So this is not just like one report that was lost. This is like 300 documents, a lot of documents. So again, we're going to play for you what happened last hearing just for a couple minutes to see what happened and how he dealt with it. And then we're going to show you what happened today's hearing. And then we're going to talk about the case law and talk about the motions that were filed so that we can get a good understanding of what happened and perhaps what should have happened, at least in my mind. Okay, so we'll start again with last hearing, and let's see how they deal with this issue, how the judge deals with this issue.
Right. So before I deal with the prejudice issue, it seems to me that I ought to know what is new and what you think is materially new. Okay. And I know that puts a burden on everybody to work together, but it seems to me that we ought to do that.
By the way, I want to give a shout out to the Trial Channel, who I am using this video from. So my buddy at the Trial Channel doing great work. Definitely go subscribe to that channel. Anyway, let's move on.
I have two other matters on this morning, so we're gonna break by 11:30 today. Okay. I think I can begin by taking evidence on the question of where has this stuff been and why wasn't it turned over earlier.
So did you hear that? I think I can begin taking evidence into where has this stuff been and why. That's a very important question, as we're going to see more later in the case law. But why wasn't it turned over earlier? That's an important question. So even though, despite him wanting this chart at this hearing, he wanted this chart, he wanted to know exactly what discovery we're talking about and what was late, what was new, what's old. He wanted it all, but then he said, well, we can still figure out where has the stuff been and why it hasn't been turned over in almost 4 years. That's a long amount of time.
And we're going to have to adjourn. We're not going to finish this today. And in the interim, I can have you folks get together and do a comparison to figure out this is new because it has somebody's handwritten notation in the upper right-hand corner. This is new because it's the full unredacted video, and the redacted video of 12 seconds is the only relevant portion, or whatever, okay? And we can get our arms around materiality, we can get our arms around prejudice, and maybe it will also focus some of the attention on why wasn't this turned over? Because it may be that this is all stuff that was annotations in one person's file. I don't know. You know, I'm not saying that's the situation, but it'll focus us a little bit. But it seems to me we can use the morning well by beginning on the first question, which is why wasn't this turned over in a timely manner?
So that's a great idea. So you're saying, yes, I do want this. And therefore, after this hearing today, you guys are going to meet and confer. You're going to get together. You're supposed to create this chart. Okay. But we still have work to do. There's still a purpose of having an evidentiary hearing, which is why they then conducted an evidentiary hearing. So just to also, again, this is not the only time he talks about it, because then they talk about it a little bit later when they're talking about work product. So listen to him right here, because it seems like he is a different tone, let's just say, than what we heard today. So let's hear this part of the hearing.
Order in another matter, we'll deal with it.
Thank you.
Okay.
And the other part of this is these were, and I'll just pass them up to Your Honor. These were the subpoenas that both ADA Hickman and ADA Lally received from counsel, seeking production. It probably dovetails with counsel's request for all the emails. I would ask that the court quash in so much as the request for the file and any work product. And
so basically, what the prosecutor is asking here is that the judge should suppress any emails that have to do with work product, that have to do with this situation, with the discovery with Adam Lally. He wants all of that quashed or suppressed. So let's see what the judge says.
Anything that goes beyond Rule 14, mandatory discovery, anything that involves work product, mental impressions, or anything as such, should not be part of this questioning.
So right now, part of this questioning is, what did this ADA know?
Right.
What did he do?
Thank you.
Okay, who did he talk to? That's arguably work product. It gets discovered in this context, because the question is, why wasn't this stuff produced in 2021?
Because the question is, again, what's the question? Why wasn't this stuff produced in 2021? That's a great question. Remember, he talked about that question before. That's the first question that he said. First question is why? Why wasn't it produced in 2021? We got to get to the bottom of that question, right?
I understand that could be embarrassing for the office. I understand that could be embarrassing for certain individuals. That's where we are right now in this particular case, because lots of stuff from 2021 wasn't turned over. Okay. So it may be that emails become relevant to this testimony. Okay. Who knew what when, and what did they do or didn't do in order to follow up? So I'm going to have to deal with this on a question by question basis. I cannot quash it across the board. All right.
Okay, so there you go. There you have it. You see his tone. He wants to get to the bottom of this. It's a very important question. Why was this stuff not turned over? Why did it take so long since 2021? Okay, so that is what happened in the last hearing. So now let me just play for you a small clip of what happened in today's hearing. And then you can kind of see the difference, and we'll talk a little bit about why I think that happened. So let's just pull this up. This was streamed by NBC Boston, and then also Brother Counsel right there. He streamed it for everybody. So that's that guy right there. All right. Anyway, so let's not get distracted by him. Let's play what happened today.
All right. So how do I compare what you have to what the Commonwealth has provided me?
So again, they're talking about the chart. So what happened here is that apparently there was no meet and confer. They did not get together and create a chart together. They each had their own chart. So the Commonwealth has their own chart that they submitted to the judge, and the defense attorney also had her own chart that she submitted to the defense to the judge. And now he's looking at both charts. He's like, "So you guys didn't do what I said, right?" Okay, but remember, there was still a very important question that he thought that should be explored at the last evidentiary hearing, which still this is not going to answer. This chart's not going to answer that question. But listen to what he does with it here.
I need you to be on the same page. I need you to go through every single document that was produced that you base your motion to dismiss on. Every single one. You have to address every single one, okay? And you have to make a chart saying this was produced in Discovery Packet 1. This was never produced before, okay? I don't need argument associated with it. I just need to know the universe of the problem. I need to get my arms around the scope of the problem. And then I need to know, with respect to anything that's new or substantially new or partially new, why you're prejudiced by the late disclosure of that additional information.
Understood, Judge.
So I don't have that here, right?
I thought you did. I understand now you don't follow it the way that I followed it.
Well, I don't understand it. So I need you to explain to me why you think I do have that.
So he's saying you need to go through every single document, all about 300 documents that were turned over late. You got to go through each one, put them on a chart, and show me or argue why. Well, first, that's what he wants. Okay, first put them on a chart and let's see what was turned over late. And get together with the prosecutor and put this chart together. And then also, he's going to say, well, we have to also then discuss how each document is prejudicial. Why the late disclosure of that document is prejudicial to your case, and why the defense is not going to have a fair trial now.
If I do.
Well, I think you have part of it, Judge. I don't think you have all of it.
All right. So I need all of it.
Okay.
Okay. So I understand the scope of the problem. And then I can analyze the question of prejudice. After you've analyzed the question of prejudice.
Yes, Judge.
So how are we going to do this?
We're here at 9:24. I'd be happy to meet with the parties downstairs for the next 3 hours.
I think that would be a much more productive use of time than putting Mr. Lally back on the stand.
Uh-oh.
or anybody else, because there are real constraints on the court's ability to provide a remedy beyond the remedy that has already been provided.
And he's talking about the remedy that was provided was the fact that he was out on bail and that the trial was continued, so they had an adjournment. That was the remedy that already happened, and now the last remedy that she's asking for is dismissal. So he's saying there's some constraints on that. And we're going to see where he gets that from in a moment. But this is what his position is. What do we have to get Lally on the stand for now? When you got to figure out which documents came later and go through those 300 documents, and then we'll talk then.
Absent real showing of
Prejudice.
meaningful prejudice. And
so you got to go through and those documents and show me that there's some meaningful prejudice in the fact that you didn't get those documents turned over earlier, right? So what happened in the interim? What happened between the two hearings? Why is there a change of this tone? Remember his first question. His first question is still valid. Why? Are any of those documents going to tell you why they weren't turned over? They're just going to say you what discovery was not turned over and what discovery was turned over later. That's all that chart is going to show. And then, yeah, you can start making arguments about prejudice, but is it going to answer that question of why? It's not going to answer that question of why. The only way you're going to get why is if you get people on the stand and ask them why. What took so long? Why did you not turn this over? Where was this? Were you being willfully ignorant or you just ignoring things? Well, what's going on here? That is how you get to the answer of why. If you care about why. Now, is why an important question? Maybe why is not really an important question. Maybe that's what changed here. So in order to understand this, right, in order to get a little bit better context, let's pull up what was filed. Okay, because something just was filed between the two hearings, and maybe that's what the judge looked at and said, oh, maybe this person has a point, and that's why I'm going to completely change my tone here. Okay, so this is what was filed. All right. Maybe you've seen this before. We'll just kind of go through it quickly and point out some of the parts that we have to talk about. Okay, so this is filed by Adam Lally's attorney. So Adam Lally got an attorney to represent him for this hearing. Okay, which already is the first interesting thing that's going on here. You're an attorney. You're talking about what you did on a file. You're not being sued. It's not like he's being sued for malpractice or something where you need to be represented. This is an evidentiary hearing about a file that you're handling. So this could very well be dealt with by yourself. But okay, can you blame an attorney for getting representation? Maybe not. All right, so it starts off talking like this. The court should suspend Lally's testimony unless and until the defense makes a preliminary showing as to all three required prongs required for dismissal. Number one, egregious government misconduct. Number two, prejudice to the defendant's right to a fair trial. And three, a showing that dismissal is the only remedy for the prejudice. So, recent procedural background. So this is now trying to pull everything together. We'll try to get through this kind of quickly because I really want to move on to the research that really controls these issues that are in front of the judge. Okay, so it's not really so important about what this lawyer says is important. It's about what the law says, what the case law says. So let's try to get through this. It's not such a long motion anyway. The hearing on the motion was scheduled for July 21st, 2025. Assistant District Attorney Adam Lally was issued a subpoena by defense counsel to appear at that hearing in this matter scheduled for July 21st, 2025 at 9 a.m. He appeared and began testifying over his attorney's objection, as we know. At that hearing, the court directed counsel for the defendant and the Norfolk District Attorney's Office to work together to specifically identify the scope of discovery that was disclosed late to the defense. Right? We spoke about this. We saw this. We heard this with our own ears just a few moments ago. The court also directed counsel for the defendant to review the materials and to identify specifically any exculpatory evidence that was disclosed late to the defense. Meaning if they're sitting on something that just shows a video of the defendant shooting the victim, so then that's not exculpatory exactly. Continuing, Attorney Lally testified on July 21st, 2025, and the hearing was continued until today, August 5th, 2025, with the expectation that the parties would have narrowed the scope of the discovery at issue and counsel for the defendant would have identified what she claimed to be exculpatory and prejudicial. Before Attorney Lally's testimony recommences in this matter, counsel for the defendant should comply with the court's directive and identify how the evidence at issue here is exculpatory and how the defendant has been prejudiced, particularly given that he has been released on bail and the trial has been continued. You see those two reasons? Particularly because he's been released on bail and the trial has been continued. So meaning the two reasons, one of the two reasons that you filed this motion was so that he should get bail, which he was granted. Number two, that the trial should be continued, which it was. And now the last issue is just dismissal. Well, for dismissal, you got to prove prejudice. Without two of the requirements for dismissal under Commonwealth versus Trepania, which is a very recent decision, the defendant's motion fails and testimony from Attorney Lally becomes unnecessary. Should the court still wish to hear from Attorney Lally, we, the undersigned counsel firm, respectfully suggest that his testimony should be strictly limited to the issue of whether his conduct constitutes egregious misconduct, which, in light of the 26 notices of discovery provided unique discovered each time, certainly does not. Okay, so this is his attorney. Now, this case of Commonwealth versus Trepania, so listen to this. Last week, the appeals court issued its decision in Commonwealth versus Trepania. This is last week. This case is worth a close study. Like this case, it emanates from an allegation of late disclosure of evidence that was ultimately disclosed pre-trial. In that case, so he's saying this is exactly the same case as Trepania, which just came out last week. What's happening in this case of Miles King is exactly what happened in Trepania, and therefore you should follow the decision, the holding in Trepania. That's essentially what the argument's going to be. We're going to see if it's similar in a moment. In that case, the trial court issued an order to produce the discovery, but included what should have been excludable time under Mass Rule of Criminal Procedure 36, which is the rule for a speedy trial, ultimately leading to dismissal. The appeals court was clear that dismissal of the charges as a sanction for a violation of that Rule 14 in the absence of a finding of irremediable harm was an abuse of discretion. Footnote 8 of the decision, the appeals court acknowledged the 2025 amendments to Rule 14, including to the sanction provision, but wrote, we discern no substantive change in this language. Rather, we think it merely provides an illustrative list of sanctions to aid litigants and judges. A dismissal with prejudice under Rule 14 still requires a showing of irremediable harm. In order to warrant a dismissal, there must be egregious prosecutorial misconduct and prejudice to the defendant's right to a fair trial, and dismissal must be necessary to cure the prejudice. The remedy of dismissal is only warranted when there is egregious government misconduct, prejudice to the defendant's right to a fair trial, and a showing that dismissal is the only remedy for the prejudice. In this case, should counsel for the defendant fail to identify for the court how any of the documents at issue are exculpatory, and therefore the late production prejudice his right to a fair trial, and where counsel for the defendant fail to show how dismissal is necessary to cure the prejudice, given that the trial date has been continued and the defendant is released on bail, the defendant's motion can be denied without further testimony from Attorney Lally. So this is what Attorney Lally's attorney is saying. That, look, why are we jumping the gun here and having an evidentiary hearing? Meaning, well, Judge, what you said in that first hearing is actually wrong. That's essentially what this attorney is saying. And this is Pat Hanley. Pat Hanley is the attorney that's representing Adam Lally. So essentially what he's doing is what he's saying is, Judge, until and unless you get this chart, which shows all the discovery that was outstanding or late, and the defense attorney can show and explain to you why each of these documents are prejudicial, and it's not going to be a fair trial, and there's egregious misconduct, then this doesn't warrant dismissal. So what's the point of having an evidentiary hearing at all? There is no point. That is the argument here. Now, this is what was submitted to the judge before this hearing. So you can imagine that most likely what happened was the judge saw this motion and said, hey, okay, that's interesting. Maybe he's got a point here. Maybe the judge did some research and said, you're right. Maybe we should not have an evidentiary hearing. Maybe we should not call Adam Lally to the stand or former Trooper Michael Proctor. And let's just see if the defense attorney can identify which of those documents that were not turned over timely somehow prejudice the defendant in this case. Now, again, I don't know the details of the case. From what I'm hearing about the case is that they have a very strong case. With the evidence, it's very, very strong that the defendant actually committed this crime. Okay, that's what I'm hearing. I didn't do a deep dive on the actual facts and evidence in this case quite yet, but that's what I'm hearing. So she's going to have to figure out which one of these documents, if she would have had it earlier, it would have helped the defense. So, for example, let's say one of these earlier documents would have identified a witness that would have helped the defense, and now the witness is gone or the witness died. That would be an example of prejudice. So that's what she has to do now. That's what the judge is requiring her to do. I mean, the first thing is to create this chart that he wants. But let's take a look at the case law for a moment, shall we? Okay, so first let's talk about Trepania, because this is, after all, the case that he cited. Now, let's take a look at what happened in Trepania. It's always important to know what happened and then see if we're comparing apples to apples. A complaint issued on October 7th, 2020, and the defendant was arraigned in February 2021. Now, this is the case of Trepania, on 3 counts of indecent assault and battery in violation of that statute. The final pretrial hearing was held on March 17, 2022. At that time, the Commonwealth represented that all mandatory discovery was completed and made no mention of DNA evidence. The judge set a trial date for June 2nd, 2022. So, final pretrial, the prosecutor says, we gave over everything and did not mention anything about there even being DNA evidence. In April 2022, a different assistant district attorney was assigned to the case. Okay, that may be similar to this case. That month, she disclosed new evidence documenting that a male DNA profile had been developed from saliva on the alleged victim's neck and moved to obtain a DNA sample from the defendant. So you see what happened here? That was the only thing that was not disclosed. Now, it's an important thing, right? DNA evidence is important, but that was it. That was the extent of what was not turned over in this case. Okay, and that's where he quoted this case standing for this proposition that, well, you got to show that it's prejudicial and, you got to show that it's exculpatory, whatever. That's when he was citing this case. Let's see if we can get there for him quickly. Here. Without 2 of the requirements for dismissal under Commonwealth v. Trepania, the defendant motion fails and testimony from Attorney Lally becomes unnecessary. Okay, so that's what Trepania says. But there's another very important case that you also have to consider. Okay, and this is also part of Massachusetts case law. So this is part of the law in Massachusetts, and that is the following. There is 2 different reasons, okay? And in fact, this case really says it directly, how to analyze a Rule 14 violation and whether it rises to the level of dismissal. So let's take a look. Third, that's it. This is the only part of we're reading about this case, so don't get too scared away. Third, dismissal with prejudice is a remedy of last resort that you've heard a million times, and that's true, right? The courts always favor adjudicating matters on the merits. So just to dismiss with prejudice because of a violation or a sanction is always frowned upon. It's a remedy of last resort, but may be available in certain limited circumstances. 2 parallel legal principles balance the rights of defendants against the necessity for preserving society's interest in the administration of justice. Under the first principle, where the prosecutor fails to disclose evidence the defendant is entitled to receive, and the defendant is prejudiced by the failure to disclose, a motion to dismiss should not be allowed absent a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. So this is kind of what we were talking about in the beginning. When you have the prosecutor failing to disclose certain evidence to the defendant, and because of that failure, the defendant is prejudiced because, let's say, it identifies a witness who died. So that's irremediable harm. You have to show not just that the prosecution failed to turn over this discovery. You also have to show that you're prejudiced and the prejudice harms you in an irremediable way. It's irremediable harm. And therefore, the defendant cannot possibly have a fair trial. Such a drastic remedy would be appropriate where failure to comply with discovery procedures results in irremediable harm to the defendant that prevents the possibility of a fair trial. Alternatively, here, listen closely, prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to presumptive prejudice, and the drastic remedy of a dismissal of charges may become an appropriate remedy. The latter theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct. And then they cite some cases here. Bridgman. The only reason to dismiss criminal charges because of non-prejudicial but egregious police misconduct would be to create a climate adverse to repetition of that misconduct that would not otherwise exist. And then again, in setting another case, the indictment itself is so inextricably interwoven with the misconduct which preceded it that the only appropriate remedy here is to dismiss the indictment. So the analysis does not begin and end with showing prejudice and irremediable harm. You're right, that's the first principle. That's one of the principles, but there is an alternative. And the alternative is that if the prosecutorial misconduct is egregious, deliberate, intentional, and you need to deter this from continuing. So what would be an example? Well, the example like this would be, for example, let's say a police officer, a trooper, decided to hide certain evidence, which could very well help the defendants. And he did it intentionally, egregiously. Now, even if technically that what he was hiding was not prejudicial to the prejudicial that the defendant did not have it. And now that he has it, okay. But if the prosecutor, the trooper, was doing it maliciously, intentionally, because he didn't want the defense to have this piece of information, if that can be proven and you have to deter that type of conduct, then also dismissal can be considered by the judge. So what I would say is that the judge initially actually was correct. The fact that we need to know why this was not turned over for 4 years. Is this a situation where something a paper or two got lost in the shuffle? Is this a one DNA report, which is not exculpatory in the slightest? Is that what we're talking about here? Or are we talking about 300 documents that were not turned over in 4 years? Can that maybe lend somebody to believe that this was not an accident? This was intentional. This was egregious. And maybe it may actually rise to dismissal because you have to deter this type of conduct from continuing. And when you're dealing with these former Trooper Michael Proctor, that may have been the conduct that he was showing. Who knows? But the only way we're going to get to the answer of why is when you have these people on the stand, which is why I think everybody was there. They're all there. So you're right. You don't have exactly all 300 documents showing you what date it was received. It was late. It wasn't received 4 years ago. And you don't have arguments for each document saying why you're prejudiced by that document, but still, there can still be enough of a reason to have an evidentiary hearing to see why. Why was this not turned over for 4 years? Was this just such a tremendous incompetence by 5 different people at the same time over 4 years? Or was there something more intentional going on? And if that could be proven, then there can also be a reason for dismissal, as we just explained. So I think that the reason why the judge changed the tone a little bit in this hearing was because of this motion that was filed by Adam Lally's attorney, and he did a good job. He actually, after all, he's representing Adam Lally, so he's not going to want to bring out all the points that I just brought out. But this is the argument back. The argument back is that it's not just limited to prejudice. Now, of course, that is the easiest way to go about this, to show that there's some prejudice here by not having this information. But there's also this other part, which has to be explored. And the only way that you could explore it is with an evidentiary hearing, getting Michael Proctor on the stand and asking him, all right, tell us why this took 4 years to turn over. Explain to us how incompetent you are and how mistaken you are that you're just no idea about 300 documents being turned over. Tell us why all those meetings that you had with Adam Lally, getting these documents when he was asking for these search warrants or whatever it is, that you just didn't turn over. Are you just that incompetent, or there was something more going on? So when you're dealing with the difference between one document or 300 documents, that can also lead to some inferences about what was going on, right? Circumstantial evidence. And number two is that you can actually get people on the stand and try to figure out more what was going on and get to the answer of why, which is what the judge started off with at last hearing, which I think he could have continued today, saying, okay, you still have to do all this, but since we still need to know why, maybe limit the evidentiary hearing somehow into that. Maybe limit it into why. That's fine. But just, okay, we're not going to have any testimony today. Everyone's here. We're all ready. We scheduled this. This is the date and time. They're under subpoena. They're ready to testify. But, there's no point of this because I need my chart. So, a judge does have the discretion to do that. He could do that. right? The evidentiary hearing, he has the discretion to cut it off whenever he wants. He can say, okay, I heard enough at any point. He could do that. They have a lot of discretion when it comes to these type of things. So does he have the discretion to do it? Yes. Should he have done it? I'm not so sure. I think there would have been a good reason to continue the evidentiary hearing and try to get to the answer of why, which is how we started off. So that is my take on what happened today. And now it was just pushed off till, what is it, August? Let's see if I can pull it up here quickly. Okay, I guess I don't know when it is. It was just pushed off. I don't know when. August something. So that's when this hearing is pushed off now. So we'll see what happens then. And maybe he's going to require, maybe he's going to follow what Adam Lally's attorney said that he should follow. He's going to follow that script and say, okay, you have to show me prejudice. And if you don't, then we're not having the evidentiary hearing. Adam Lally's not going to take this in. Maybe he'll do that. And we're not going to get to the bottom of any of this. That may happen. So prepare. And again, this is not a case where, like you have a Karen Reed case, where the prosecution does not have stronger case, from what I'm hearing. This is a case where the prosecution has a very strong case. So to find something that's prejudicial that would have actually helped the defense in their defense may be more challenging in this case than it would have been in the Karen Reed case, for example. In Karen Reed case, they absolutely should have had an evidentiary hearing. There's no question about it. They should have had an evidentiary hearing about the missing footage, the surveillance footage, all that, the Sally put footage, all that stuff. They should have had an evidentiary hearing. There's no question about it. Here, again, there may be a little bit of a harder argument because it could be he's so dead to rights. And again, I don't know the case so well, but that's what I'm hearing. So we'll see what happens with this case. So that's going to be it for now. If you haven't yet, please subscribe and like, and we will see you next time.